Hello everyone, I'm Anuj Jaggi and I'm a legal intern with LEXIS and Company, and the topic for today's video presentation is Impossibility of Performance. So section 56 talks about agreement to do an impossible act. So when one person has promised to do something which the conditions are under, he knew the second one with reasonable diligence, and with which the promisee did not know to be impossible or unlawful. Such promiser must make compensation to such promisee for any loss which such promisee sustains through the non-performance as per the promise. So supervening impossibility or illegality makes a contract void. Under the second paragraph of section 56 states that a contract to do an act which after the contract is made becomes impossible, or by the reason of some event which the promiser could not prevent, unlawful, becomes void when the act becomes impossible or unlawful. So further effects of such agreement, which is given under section 65, are under the earlier English law, which is recognized the rule of absolute liability in case of contracts, which later changed to the doctrine of frustration. In the landmark judgment of Taylor versus Caldwell for the doctrine of frustration, a contract becomes void if the subject matter of the contract ceases to exist without fault of either party. The facts of the case were the claimant hired out a music hall in Surrey for the purpose of holding 4 grand concerts. The claimant went to great expense and effort in organizing the concerts. However, a week before the first concert was due to take place, the music hall was destroyed by an accidental fire. The claimant sought to bring an action for breach of contract for failing to provide the hall and claiming damages for the expenses incurred. So if contract performance depends on the continued existence of a person or a thing, and that person or thing ceases to exist without fault of the either party, then the performance may be excused for impossibility of performance. In this case, both the parties are excused. So further, another case was where Supreme Court held in Satyabrata Ghosh versus Mugniram. The temporary requisition of land by the government does not make the contract for sale of land void by reason of supervening impossibility. So under this case, the facts were that Satyabrata, who was the plaintiff, assignee of Bijoy Krishna Roy, sued defendant along with Bijoy as party defendant for wrongfully repudiating the contract for developing the lands which were sold to the plaintiff, and asked for specific performance of the same. The defendant took the defense of frustration as the lands which needed to be developed were temporarily requisitioned by the government under defense rules such that for unspecified period at any time. The contract was made at a time when war conditions were prevailing, and any such requisition was any such requisition was reputed to be in the contemplation of the parties while forming contract. Further, no time was specified in the contract. So the issue was that whether the contract for the sale of land was discharged and came to an end by reason of supervening circumstances which affected by performance of a material part. The contentions of the plaintiff, that were the doctrine of English law relating to frustration has no application in India, that there was no frustrating event. But the decision of the court was that impossibility under section 56 doesn't mean literal impossibility to perform like strikes or commercial hardships, etc., but refers to those kinds of acts or cases or situations where a supervening event before the contemplation and control of the parties, like the change of the circumstances, for example, destroys the very foundation upon which the contract rests, thereby rendering the contract impracticable to perform and sustainability useless in view of the object and purpose for which the parties intended to achieve through the contract. Further, firstly, war conditions were known to the parties while entering into the contract, such they were aware of the possibility of the difficulty in performance of the contract. In such circumstances, the requisition of property did not affect the root of the contract. Secondly, no stipulation as to time was provided in the agreement such that the work has to be completed within a reasonable time. But having a regard to the nature of the development contract and knowledge of the war conditions prevailing during the contract, such a reasonable time was to be relaxed. Therefore, the contract had not become impossible of performance under section 56. So this was the concept of impossibility of contract and doctrine of frustration, and I would continue it in the second part of the presentation or the second video presentation. Thank you.